Right, good morning, everybody. Welcome to this late start of the Central Otago District Council Hearings panel hearing. My humble apologies, everybody, for delay. Quite as you planned. Anyway, I should have been better organised. Just some procedural stuff to get underway with first. If there are no apologies, and we have got minutes to be confirmed. Item 2516.1. The meetings on the 8th of July and the 14th of October. Were we both all here for all of them? No, you weren't here for one of them?
In October 1. I can move July.
No, we'll just do them as one. So Ian can move and I can second.
All right.
Sound good? All in favour? It's carried. Is that done? Thank you. Move on to item 2516.2, which is a resource consent 250157, Kevin Jarvis. So the property convened meeting of the hearings panel called for the purpose of hearing a resource application to subdivision and land use consent at 8 Highlands Avenue, Cromwell. Ask the minute secretary report on proceedings to date.
All statutory requirements under Section 25 of the Resource Management Act have been complied with. The Section 42A report by the planning consultant has been circulated to the address for service.
So the following procedure will be followed for the hearing. The panel may ask questions. Council's officers or its consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence. Section 42A report writer will be invited to provide a right of reply following the hearing of evidence and submissions. The applicant then has a right of reply but should not be permitted to again traverse the evidence nor raise new evidence. So before proceeding with the hearing, I'd ask that all parties appearing identify themselves. I'll start with the panel. So I'm Neil Gillespie, the late chair. To my left, Councillor, basically we're commissioners for this hearing. Yes, we're commissioners at the moment. Commissioners Martin McPherson and Ian Kearney. To my right is Taryn Lyons, who makes sure we do things right on time. And Jessie is learning to take over from Taryn to that. Our Section 42A report writer is online from somewhere not here. McIntosh and Anne Rogers, who is the technical advisor to the panel. That's us.
Thank you. I'm Zoe McCormack. I'm work at Landpro and I'm the consultant for the applicant. Yeah.
I'm Kev Jarvis, the builder.
Good, and the builder.
Yeah, I'm the builder.
Welcome, people. So not too much of a formal process, but we just got to make sure we dot some I's and cross some T's. I asked one of the panel to move that the Section 42A report be taken. Moved. Martin, seconded. Ian, I carried. So I understand that you have no evidence to present.
No evidence.
Any comments, observations you want to make? Anything you want to say? This is the important thing.
Here a summary for today. If you have time, should read the summary. I didn't circulate anything. It was just a summary of my notes.
Yeah. Thank you. Yes. Yeah. Looking blankly is like, you get to read something.
No, you did not. Sorry. Yeah. I emailed Karen.
No, we'll just get a copy of that, and then like just seeing we haven't had a chance to read it, might get you to take us through it. Otherwise, it'd be painful silence while we sit there and read it. Might be if you read it, then I'll often find that's a better way to anything that we might have missed. Thanks. Okay, thanks, Zoe, for the statement you've got. Back page is more bullet points.
Yeah, they were just notes.
Just notes. Okay,
right. Yeah.
Okay, right.
Nothing additional.
Do you want to just whip through anything key out of that for you? Pretty clear what the consent's about. Just maybe just focus on things that you think are important for us to bear in mind that when we make our decisions, it's probably the best thing to do.
Yes, yeah. I think a few things that are key to note is that the Highlands Innovation Technology Park, while it's zoned rural, is inherently not a rural site. The the fact is that all of the effects of the proposal are internalised entirely within the Highlands Innovation Technology Park, and the applicant has sought the approval from the Design Review Board, Highlands themselves, and also the neighbouring landowner, where there will be a party wall joining with number 10. While this site in particular doesn't benefit from 100% site coverage, we are increasing the site coverage on these two lots that we've applied for, beyond that required by the consent notice. And so there is that existing understanding there of having some development within the site that has higher site coverage and lesser landscaping. We've got as far as I can summarise, all effects at least are minor or less. The landscape is a high design nature of the dwelling, which compensates for that, the dwellings. You can't reconcile, it's very difficult to reconcile the proposal with the policies in the plan. However, we don't think that it's inconsistent with the receiving environment as it's been authorised to occur. And regards to the Barker-Ballantyne decision, that was raised as one of the key questions in the Section 92 request relating to whether or not consent notices can be varied. We found that that was an interesting case to consider, but it was sufficiently different to the site here that it didn't mean that you couldn't then grant consent notice, change to a consent notice. And there were some parts of the Barker-Ballantyne decision that can't apply here. For instance, Barker-Ballantyne was considering an environment where there was a plan and a proposed plan, which considering the community's expectations for that area. It was also an appeal on a decision that were conditions that were imposed on the applicant, which they felt that they had to agree to but hadn't. So that was sort of the grounds for the appeal. And that we believe that you can grant changes to consent notices in general, but particularly for this site because it is so unique in the Highlands with regard to the reduced landscaping and the increased site coverage, which is consistent with the existing environment.
Right, thank you. So probably unsurprisingly, my question is going to be about the consent notice, whole variation process. I interpret this application, and there's some other ones heading this way later today as well that are very similar in that respect. The Highlands Design Review Board and the Highlands, the name is the affected party, are seen as being, if they're okay with it, then it's okay for the consent notice to be varied. So my question is, what about all the other people that are there that didn't think about, haven't gone through a process of varying the consent notice? Do they have any, this is the wrong word, but should implications on them be considered or not?
I think that because, so yes, the consent notices apply for all of the lots that are in there in stage 1 and stage 2. And there is a pathway to apply for variations to consent notices. Each of the owners in Highlands are required to submit a design plan to the Highlands Design Review Board. So each owner has an expectation that whatever they propose has to be agreed to by the Highlands Design Review Board. So long as their design that they're proposing is approved by the Highlands Design Review Board, that's the test that applies to everyone.
Your contention would be is that all those that are subject to the consent notice should accept, if the Highlands Design Review Board deem to approve something that's outside the bounds of the consent notice, that should be taken as being people that are subject to the consent notice.
They don't speak for all people subject to the consent notice, but they apply the same test that applies to all others in the same subdivision. So each design has to be submitted to the Highlands Design Review Board, and there will be an understanding from everyone in that what they propose has to be of a standard which they will appreciate for the Highlands Design Review Board to administer.
Need for us. And I say that quite cynically because doesn't sit. I get what you're saying, understand that, but
Yeah.
it seems an interesting process that probably haven't come across it before, but probably never had a situation where it turned a mind to it. So
But the design review board is greater or influence than the consent over the consent notice.
I think that's what they're saying is that
No, that's not what
if the
I'm
design
saying.
review board has said it's okay, then they've considered that in light with what the consent notice says as well, the bigger picture. So therefore, we should be satisfied to take that as being justification for variation of the consent notice.
Whether or not other parties are affected by the change to the consent notice, you're right, it sits as a separate question with yourselves and the council that makes the decision on any affected parties. The council officer has deemed there to be no affected parties beyond those that we provided the written approval from. They have the determination as the council determines who's an affected person by the proposal. I guess I'm trying to substantiate that there is a process that all of the parties are subject to, which is going through the Highlands Design Review Board. So if any applicant wanted to make a variation to those design protocols, they would first have to go through the Highlands Design Review Board. Not to say that anyone hasn't wanted to, or they've been comfortable with the design that's been imposed on them.
So in effect, the design review board is the quasi affected party for everybody in respect of the consent notice. That's what the application is suggesting to us very strongly, saying, hey, these guys have said it's okay, therefore it should satisfy the council that it's okay. And as you said, our reporting officer said it's enough, no further notification required from me. Al's asking the question going, is that right? I'm not saying anybody's wrong. It seems it's something that hasn't come across this table in my time anyway, in the way that's and Highlands is quite unique in the first place. The idea is that if this was its own zone type thing, as it will one day become, as opposed to a piece of rural land, that'll probably pick up these sort of issues and going forward. But yeah, no, you've expressed to me what I thought the case to be, and I understand the logic behind it. I'm not saying it's wrong, and see why it can seem to be right. I don't know. Ollie's got to say, he's certainly now got the gist of a question that I'm going to be asking him. Haven't you, Ollie? Any other questions from the panel?
Sorry.
Right. Yeah. Anything technical from your point of view?
No,
Right.
see what he's got to say.
Yeah. Right, Ollie, we're handing over to you now for your right of reply to your Section 42 report. You might have heard my comments about the consent notice. I'll be very interested in what you have to say about that with your right of reply, which should hopefully pick up the issues that I've raised. If it doesn't, I'll re-ask the question.
Sure, I'll do my best. Look, I hope it's come across clear in my report anyway. I guess I too am not fully comfortable with the scenario that this one's one of those ones that's put forward a situation where on the one hand, the effects are very much internalized and there's not a great deal to this in terms of effects, which is obviously what we primarily are and to be concerned with under the RMA framework. On the other hand, you've got a consent notice, and consent notices, something that we know are steeped in case law. And we've got some pretty clear directions from that case law with how to treat those consent notices. Right, I've summarized that a little bit in my report. Ballantyne, Barker Holdings versus Queenstown's probably the most commonly cited case. And I think that's probably because the judges in that case were quite helpful in the way that they sort of summarized and set out the questions that the court came to that they suggested should be asked when considering these sorts of applications. The reality is that that Ballantyne case followed on from a number of other cases going back, quite a few years. I know before Ballantyne, we used to generally quote Foster versus Rodney District Council, which I think was a 2009 case. And then since Ballantyne, there've been some other ones. So it's the point I'm making there is that the principles that have come out of those have been reinforced time and again by the court. So it's not a single case that's, one judge's opinion. The courts reinforce this again and again. And the principle that they've reinforced are that consent notices, an application to change a consent notice needs to be treated quite differently to an application to change a general condition in a resource consent. Consent notices are a different beast and carry with them, should carry with them a degree of certainty that's sort of above and beyond what you'd get from regular consent notice conditions and arguably also regular district planning standards. I say that because really in this situation, the consent notices are effectively standing in for district planning standards where we've got an underlying zone which really doesn't suit the development taking place at this site. So the long and short of it is, I think it's a difficult decision for the panel to make today. On the one hand, speaking strictly of effects, there's not a great deal to it. On the other hand, I don't think this application does. It's not a comfortable or particularly persuasive fit in terms of those directions the court's given around consent notices. Does that at all answer your question, Mr. Chairman, or have I confused matters further?
I won't say you've confused matters further. I guess the big thing for me is consent notice, in this case, impacts on many other people.
Yes.
This application and others we're going to be considering later today, ironically, are suggesting to us that it's appropriate that the Design Review Board approval effectively, because of their role in all of the developments, if it fits with what their role is as applicant, as everybody who lives here knows and understands, then that should be sufficient for the panel to be to grant consent. That basis. And I'm not saying that's right or wrong. This seems to me to be a little bit, I'm going to say unique, because I don't think I've ever seen something that's had a consent notice that's probably affected so many, with the Design Review Board situation in there as well. And what I guess I'm mindful of is that there's a risk here that other people might, for whatever reason, because of how they've done things, not be aware this could be happening, and they could be happy or unhappy about it. I don't know. I'm not saying that should affect whether we decline or grant the consent. And I think you're right to say it makes it even less relevant, because you've got a planning framework that doesn't fit the site. It's a creature of its own, and it's almost like you've got to put that to one side about the why it's non-complying. Because, correct me if I'm wrong, if it wasn't for the non-complying status, it would be discretionary or restricted discretionary in relation to the consent notice, wouldn't it?
That's correct. It would be discretionary. Yeah.
Which means you wouldn't have a panel sitting here doing what I'm doing at the moment about it.
look, I mean, really, the question of whether all the landowners in there are affected persons was something, again, I certainly put my mind to, and ultimately, I guess, again, there's a tension here. On the one hand, there's a threshold of effects that needs to be met for those other persons to be deemed affected. Whether or not that, and on the other hand, you've got a consent notice, so they've got a, I guess, there's an expectation that carries reasonable certainty around the outcomes sought by those consent notices. What gets tricky is how much how much that expectation makes them more sensitive to effects. Because really, in this case, my view of it was, well, certainly the neighbour, the directly adjoining neighbour, is affected. The applicants have provided their affected person's approval. Are other people are the landowners in Highlands affected by this? In other words, are there direct effects on them that are at least minor? Ultimately, I've concluded no, there aren't. But it does raise the fact that there is that consent notice and that those people would by rights have an expectation that there's going to be a certain amount of landscaping and site coverage for these sites. It does make that particularly tricky. Ultimately, I've fallen on the side of it's tricky. It might go against what they were expecting, but that's not eventuating in direct effects on them.
I think your discussion just led me to understanding something a little bit better. Reality is that if you are a neighbour, with them not to be affected, or anywhere in the Highlands Park, and you've got a consent notice, then you should know, probably don't, but you should, and you can, and you'll be required to know that your consent notice is able to be varied through a restricted discretionary process by the council.
It'd be discretionary, but yes.
Discretionary. So I think you found me the pathway that says actually, or assessment based on the fact of what is a restricted discretionary process. Discretionary process does mean that it's able to be assessed against the framework we've got under the district plan and the consent notice, and that's how you get to where you've got to. So I think it helped me rationalise why the design review board can sort of say, actually, we can carry some weight here with this, and anybody who, for whatever reason, was to be aggrieved by any decision to grant a consent like this with a variation of the consent notice, has to be aware that it's actually a resource consent process or a discretionary activity. It's able to be done, and I think you've then assessed it as to how it should be. Like the pathway now, I understand better. It's unusual, I think, to have a review board keep speaking before able to provide some input on behalf of everybody else otherwise. So I think my dilemma is fixed.
It is, and to be honest, council has accepted the design review board process at Highlands as a sort of proxy for APAs in the past. And to some extent, I guess I took that on board here, but also, to be perfectly honest, I'm not comfortable. I don't really think that is I think that's a risky scenario. There's nothing really in the RMA that I'm aware of that directs that kind of a situation. And that's why in this case, I've not take the direct neighbour, for example. I've not accepted that the design review board's approval is a proxy for them. They, in my eyes, were quite clearly affected. to be fair, in the applicant's eyes, obviously they were also affected as well because they front-footed that and sought their affected person's approval. So I don't want to. The point I'm making, I don't want to put too much on the design review board being a proxy for other landowners in that process. I think in this case, looking at direct effects, I don't believe the other landowners met the threshold to be affected persons. And then that accepting that, then we come to those other tricky questions around, well, you know, effects to one side, are there justified grounds to vary this consent notice?
Thank you for explaining that, and I stand and acknowledge that you have not necessarily taken the design review board's position to be the determinative rights that you've been given. You assessed it on as we would if it was rules in the plan. So yeah, I thank you for helping me to get around how that works. Only thing I would say is that council's practice in the past of taking the design review board has been the council officers practice. I'm not sure it's been the panel's practice. It's probably not been to a panel. So that's the other challenge as well. Thank you. No, I have no other questions or clarifications required. Ian?
Are you able to comment on the proposed site coverage in landscaping in relation to stormwater?
Only insofar as that's obviously another reason why we have site coverage standards. I did put my mind to that and go back to the original Highland Park decisions to see what sort of discussions or reasoning was could be found in those for the imposition of those conditions in the first place. Stormwater did not arise at all in those as one of them. I think it's reading between the lines, that's whether it was acknowledged as a explicit reason. At the end of the day, site coverage has a direct correlation or direct effect on stormwater. So it is something that is relevant, I think, to our consideration now. The advice I have is, with the kind of rainfall that area receives and the sort of drainage that area has, that designing suitable soak pits for this scale of site coverage versus 75% isn't necessarily a major challenge.
The only observation I would make is just from Zoe's comments, the bullet points here, that consent notice seems to be irrelevant or redundant because of what's actually going on. It's not, but in reality, it's still there. But
Chair, that it's the matter that the panel will have to turn its mind to.
yeah,
Which I think is what Ollie's saying.
Good, Ed?
I just have one clarification. I don't know whether Ollie or Zoe can do it. It's just whether or not, I guess there is an agreement with the other lot owners that the board will make decisions on their behalf. Design board. Is that known to all parties? Who can answer that? Just a clarity thing, just to.
I believe so. Yeah, and Kevin, you would know.
Well, I've been part of over 10 developments on the park, and it seems to be the design review board is more of the aesthetic visuals of the building to fit within their agreement. So they are representing everyone as members of the Highlands because the ownership and land is changing, but they're just trying
I
to.
guess that's my question. So that's my understanding of it, was that it was about aesthetics,
Yep.
that board, but not, this is a non-complying subdivision,
And the consent,
other than a decision about the design of the building.
yes, so it is bundled as a non-compliant subdivision and a land use for multi-unit
Yeah.
variation to the consent notices. So there are multiple applications in there. So, and I agree that it is unique. I went back to read the original applications for subdivision for stage 1. And the details around why those consent notices were provided is very light. There was minimal, and the assessment that was provided at that time was also minimal. I note that it was placed in the part of the application that relates to amenity and visual effects. Not to say that that was what it was only relevant for. And then when it came to stage 2 of the subdivision, it wasn't relitigated. It wasn't reassessed again. The consent notices then applied to stage 2. Now, the Highlands application that created the Highlands Innovation Technology Park applied for 18 resource consents. And probably, here's the most stringent test for that, was a non-complying of the lot sizes creating there, and that in the rural zone being less than 2 hectares in the entirety. So I think that there is a strong argument because the existing environment has moved beyond that, and that it was anticipated that there would be some density in there, that it is, can't see it from the road and you can't access it unless you know people there. So it is interesting in that regard.
So within the design guidelines, wherever they, and the consent, the consent notice. Is there a minimum lot size? Sorry, I might have read it somewhere. Can't think.
There are, there isn't a minimum lot size.
Just the coverage
The-
density.
Yes, and it relates to different lots.
Different lots, yeah,
sizes.
yeah,
Yes,
yeah. So I guess in reality is that the original design said this sort of style of development, the only limitation they were putting was about site coverage. But pretty much every subdivision that's been done, every lot that's in Highlands could have 75% of its lot area covered in buildings.
There are some that have.
Well, yes, and some are allowed to have more, or
Yeah.
expect to have more, but the minimum was 75. And in reality here, what's happened is it's gone to 80. Simple terms, it's gone to 80. Then so you look at that, and with the way it's been assessed, it's saying 75 to 84. What's the difference? Probably comes down to apart from being 9%. What does 9% look like, and can you see it?
Yes, and you've been for a drive through the site because the development looks similar.
Yeah,
Right, yeah.
that's what it's trying to make. To say this is not untypical what's already there.
Correct.
And observation, which they say, if I drive past and look as though that's 75% or 84%, I probably don't know. Yep, that's the real answer.
Mr. Chairman, if I can jump in there, another point, because I I sat on the fence with these sorts of considerations for quite a while and thought about this quite a bit. That there is another, I guess, difference here with some of the other sites, particularly in that earlier stage 1 sort of part of Highlands, where this does have that open space area across the road from it, sort of a road that loops around an area of open space there. And so that's directly adjacent to this site. So again, in terms of looking purely at the effect of the greater site coverage and reduced landscaping in terms of this site and those immediately adjoining it around that that little area of open space, I think that's different. That's a different outcome to what you'd have if you had some of the earlier blocks going to, 85%, 90%, whatever site coverage, because they don't have the benefit of that offset from any internal or open space.
Thank you. I've got no other questions. Good. Zoe, back to you for a lot of reply. Anything you want to pick up on and send me down the right path instead of the path you think I've gone might be wrong?
No problem. I guess one other thing that's been in the back of my mind has been the application of Barker Ballantyne to this specific site. It was very clear that it was relating to there being a material change that the court determined as being as a rezoning of the land. And that is just not available in this current environment to be making any zoning or plan changes. And Highlands has been in conversations with the council about investigating that as an opportunity, but I've also recognised that they don't want to put undue workforce onto the council to come before the plan change process that was due to occur. So there's been a recognition there from Highlands that the development has gone further than when we originally provided the development at the site, applying for the application. So development has gone beyond that, and do we need to now tidy things up in terms of underlying zoning and some of the expectations like a precinct would happen through a regular plan change. So I think that that's important to recognise that it's the application itself is different enough, it's distinct from Barker Ballantyne, that it wouldn't be a conflict there with granting the consent notices. And as Ollie has highlighted, the effects themselves are minor or less, looking at it just from a effects perspective.
Understand that? Happy? The decision of the hearings panel is reserved. The full decision will be writing and valid within the statutory period of 15 working days. In the event of the release of the decision is delayed, the applicant will delay. That is now adjourned. Right, let's resume the Central Harbour District Council hearings panel meeting. Item 25.16.3 RC 250282 Dean and Michelle Telfer. This is a public convened meeting of the hearings panel called for the purpose of hearing resource consent application, subdivision and land use consent at 12 Quinns Way, Cromwell. Ask the minutes here to proceedings today.
Statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report prepared by the planning consultant has been circulated to address for service.
Following procedure will be followed with the hearing. The panel may ask questions. Council's officers or its consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the question. The applicant or the applicant's representative will be invited to make submissions and present evidence. The Section 42A report writer will be invited to provide a right of reply following the hearing of evidence submissions. The applicant had a right of reply should not be permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'll ask all parties appearing to identify themselves. The applicant and their consultant is not here, so we'll note them as not being present. Section 42 report writer is here. Our technical advisor for the panel is here, and of course the panel, myself and Commissioners Person and Cooney. Move that the report of the planning consultant be taken as read.
Second.
All in favour? Carried. Can't ask the applicant to present their case because they're not here to do that. So I'll now pass over to the 42A report writer to, as I say, it says that respond to any matters raised in evidence indicating whether there are additional recommendations which still stand or wish to amend.
So my planning report, I stand with that. In this case, it is essentially a boundary adjustment and that there are no new lots created. The applicant is intending to do a townhouse development. And so essentially there will still be built form, connected built form on each lot. So really it is just a gliding over of the boundary with one townhouse being smaller, one townhouse being larger, no changes to servicing. There is a slight right of way A to be created. But in terms of the end result, it's not going to be out of character with other development in the area. And it certainly doesn't take away from the rural resource area values for which that site is zoned. If you can take any questions.
Thank you. Don't be surprised to know that I've got one.
I'm sure.
Might even have two. So just for clarity, this application aimed for me as the chair of the hearings panel for me to consider delegating it to the environment, and I don't think it's the term. And I declined to do that on the basis that the delegation I've got only allows me to do that for something that is both minor and technical. And minor it might be, but technical it's not. So I'm unable to exercise that delegation. Stand by that decision, and I've made it several more times since then, including one this morning. It's kind of similar-ish. Can't delegate what I don't have delegation for. That has caused any concern to anybody, then take that up with the organisation. Now, I do note that there was part of the original application had a notice variation in relation to fencing, and I understand, I think I'm reading this right, that's been done outside of this process.
That's right, it was separated out and so therefore it was a non-complying activity that's come before the.
So, question is about separating things out of an application. And I'm not sure how relevant this is. First time I've come across it, but just seems to me say, oh, guys are going to go into a non-complying activity that stays here. We take it out and put it over there. It's discretionary, and therefore those big bad fellas in that room can't make a call on it. Am I summarising that right? I get why you do it, I think, but is it right to do it?
There has been a shift in the way that CODC manage variations and changes to consent notices, and that there is required to be two separate reports written for the activity. And so therefore, in this case, the section 221 variation for the consent notice was separated out. There is the standard process.
So the council did that.
But the panel gets to decide on both because they are one and the same.
No, that's not how I understood it.
That's an unusual shift in practice.
There were two separate reports written, two separate decisions made, and I forwarded it through to the planning manager and was signed off.
So just to clarify, but when it came to me, delegation, they were one.
They were
Yeah,
one.
That's why obviously I'm going, I'm confused.
So who chose to separate it?
It was Tanya.
That's unusual practice. That's
Okay.
normal practice.
That
Normal practice would be to, if they had applied separately, would be to combine the two because they are directly related. Therefore, the overall status would be non-complying.
right. So
Which is the norm.
it was combined at the section 95 stage and then separated out.
So
My
has
apologies.
the
if I
consent
haven't
notice.
Followed correct.
I don't know. I don't think
It's
you've
not
done
that
it.
someone signed it off for you.
Yes, yeah, you've done what you're allowed to do, and all I'm going, is
Mm.
shouldn't be
So has
surprised.
the consent notice been done?
Yes.
And related to something quite minor in terms of the fence.
That's
is it minor?
correct. That's correct. They wanted to erect a fence to put
Keep it off.
contain an animal in.
This wasn't a particularly
But
minor.
it's made. I don't know why that. There's a consent notice that relates to a boundary adjustment that hasn't been granted. This is a consent notice that in relation to the new lot alignment, I don't know how she could have separated the two.
Yes.
So how they don't work. If you say no,
Because the consent notice applies to the existing lot. So it will be carried down onto the new lot, but it applies to the underlying.
then it will come off.
Yes. the underlying lot.
Yeah.
It comes down to the new one.
And then, yeah, so it won't be carried down onto the new lots.
So if I understand it, on the current big lot, on the current lot that's relevant to, because they're two separate lots, it has been, one lot now has a variation of the consent notice that allows a fence for keeping a dog in.
This has the design board sign off.
Yes.
Yeah. That's why because I've seen the original application.
Yeah, what we've done is wrong, basically.
I apologise.
No, it's not your fault. It's not your fault.
And anyway, yeah, my understanding was because now that we were.
Clearly you did the
separated-
95
Yes.
Yeah.
joint and then was, yeah.
So taking it through, whether it's right or wrong, I don't think as a panel we can undo it.
I don't think you can.
So apart from noting it in our decision saying we are surprised, concerned, sort your shit out, sorry, technical term, but just seems to me to be unusual. And it's, if you look at the one I sent back to you this morning, and guess what? That's what I raised that question, so it's come to my attention earlier.
And 2 4 lot subdivisions being done under delegated
Yeah.
authority without sign off from the
Yeah.
panel.
So for the purpose of what we've got today, that decision's been made.
Okay.
It is what it is. Have to accept that. Thank you for explaining to me, and it's not a
I
reflection.
don't think that will happen again,
I wouldn't.
but I will talk to Fiona about it. She's going to be.
So no reflection on what you've done.
Nothing to do with you.
And you're probably sitting there going, he's picking on me again.
No, no.
Got me at the
I've
start.
got I'm fine.
It's kind of, it's almost planning 101.
Yeah.
Sorry.
Anyway, so today we've got a simple, as you say, you've said now, it's a simple bound, because that's what I read that, but it's not what I read the last time. So I think in simple terms here, what's happened is that the a lot smaller, one lot bigger, same outcome, same coverage. And you're saying that in terms of the rural zoning and what's already put in place, this still would comply.
Well, no.
Sorry, I'll rephrase that. It's still, so it meets the test of being able to be granted a resource consent. Sorry.
It's a significant departure from the rural
Yes.
resource objectives and policies which we need to consider. However, given in the context of the development that exists, it is a no greater departure.
So they're not breaching design, just not design site coverage or landscape.
No, all the other elements remain. All the other consent notices will be given effect to. And so really it is just making one lot smaller with a smaller townhouse, still with garaging at the bottom, and then a larger lot with a larger townhouse. And they are, so I guess you'd say they're conjoined.
I'm just checking something. Be with me for a moment. Pierce thought I had my mouth and make it. All of this. Okay, cool. So what we've got basically 2 600 square metre sections side by side, moving the boundary, make one bigger, one smaller. Site coverage is all met. All the tests in terms of how the planning framework got us here, it says, you're saying in your report, in simple terms. You see here.
I'm saying the effects are less than mine,
So the 2 existing ones are 600 each.
Yep.
I believe so.
Yeah, they are. So 1 and is number 12 and number 14 is
So one's going to 9 and one's going down.
Some,
both 601.
So what?
Site coverage is the same.
Yeah.
The combined site coverage of 75% on both. Still that case.
Mhm.
And I suppose if I'm picking this right in my mind, 75% on 300 square metres is obviously still 75%, isn't it? 75% on 900, same amount of open spaces on both. Doesn't change in that respect. Is
that was my assessment.
What happens if they come back to re-subdivide 900 square metre section?
it'd be difficult given what's going to be built on it.
It's done.
Well, if they come,
If they come back with a variation, doesn't come back to. And it's to reduce the size of the townhouse or something, I don't know.
if they were, it would have, any other future subdivision would have to come back to the panel because it's obviously non-complying. And also, I would have taken a different view had they been creating an additional lot. So in this case, there is no additional servicing demand. The built form, when looking at it from out on the street, will appear same because it's still 2 units on 2 sections. But I would have taken a different view had they been
Yeah.
creating an additional lot.
And this
What
can,
I'm saying is that, for example, with the units on it, or the townhouse side, the building. They could come back as a discretionary activity, change of condition to alter.
They could do, but every application is based on its merits and you need to assess and also.
We've just discovered quite a murky track record where that's concerned.
so that's a good aspect to pick up and saying, well, is there anything in terms of saying the place of it? It's simple and straightforward. Effectively, there's a party wall in between. So it's one building. But what I think, and what you're saying from a technical point of view, if they were to, for a build, come back for a variation, knowing it wouldn't come to the panel necessarily, it would be discretionary.
So perhaps one way to resolve that, and this is an issue that when working with another council that has been allowing a lot of kind of townhouse developments and creating fee simple subdivisions of very, very small lots. One of the requirements is that they need to, as part of the 224C stage, is that they need to demonstrate that there are at least foundations in place associated with the land use.
Prior to 224C.
Prior to 224C. So they actually undertake that. So that way you are ensured that you're not just creating an undersized lot, for example, that in the future could not be developed. It has to be developed conjoined. So therefore it will be, prior to 224C. I can look up the wording of the condition that I used for deleting.
Yeah, that's an option.
So just to follow that through, technical point of view is that we want, what we're saying is that the death by 1,000 cuts can happen otherwise. There's a risk, and we're not saying this applicant's contemplating that at all. So nothing should be construed that we're saying that they will or won't. But I guess there's another one I'm aware of where a substantial work was done, the naval title will be released the arrangement, and that shell is still sitting there. If such a condition was used, then that could still happen, wouldn't get built, doesn't matter, because actually they have to knock it down, start again. To do a very, sorry, I've satisfied myself that it's quite a complex proposal to go through.
Is there securing the design on the future titles as a consent notice?
It's mindful that in terms of the application and what we are with 42A, I think that the purpose of the hearing probably okay, what we've got. And those other matters are matters for us as part of our deliberations, if we were a mind to grant, how we might tap those issues going forward.
Yeah.
I could send you an example of the condition that used in other situations to ensure that the development, which has been assessed at the same time as the subdivision, is
because the subdivision is to facilitate the development layout.
That's correct.
If we can, I don't think it's a place where the shell would ever be allowed to be left.
Well, I think there's the controls in place that would actually. Cool.
That is correct. They do have the design board, which will.
Move on
they
I imagine
essentially act as a body corporate, don't they? to some
I think
extent.
there also, you have to be a member of the body corporate thing arrangement as well, and I'm quite sure there's be some,
Yeah.
say, if you don't, we'll take it off you and you've got to give us our land back.
I think, well, this one is probably a little, it's more straightforward than the last one. I think it is. I think in terms of going forward, changes, subdivisions, anything happening in there needs to come to the panel so that the panel has an overall picture of exactly what's going on in there. Because at the moment, a bit of a chain of events that's changing what the original panel decision was. And look, yes, it is internal and you can argue all of that, but at the end of the day, they should be doing is actually doing what we've been talking about for a couple of years and is actually doing land change. Come in and sort this out. And it really is on them, and the more eroding of this we allow, the less likely that's going to happen. If we start putting up, no, that's not.
I suppose the key thing to here to consider, what you've said to us, Kirsten, is that no extra lots.
Yeah.
That's the key, one of the key,
About this
that's what different, one of the key determinations is that might be, and that's one of the reasons why you're saying on that basis, it's, you can look at it and say, that but for the name, it's effectively a boundary adjustment.
I mean, I am mindful that it is zone rural. So when you're looking at effect, you've got to look at the effects on the rural resource area.
Right.
And so that makes it very difficult when you're a planner trying to assess the extent of the facts, because the
The reality is it's not rural.
it's not rural, it's not even large lot. You know,
It's a motorsport park. It's unique to itself. You're right. It needs its own.
needs to
it
be
needs
a
its own
special
planning
purpose
structure.
area.
It has a structure to it in terms of
Yes.
consent notices
Yeah.
for a reason. And that's what we talked about earlier with Ollie's one. It's there because the degree of non-compliance when they came through. That's why it's got belts and braces.
So the key thing about this one though is that
This is different.
this is different.
This is
Um,
not a
and-
breach of the
and
consent notice.
You've assessed it in your
Except for the
report,
fence.
assessed in your report saying what's permitted the two 600s and can happen there in terms of all consent notices. And the effects of that in the rural zone have been assessed, and against that, you've assessed the proposed change and you've said the effects are the same. And that's the key thing here. It says there goes the difference that can work through. That's what you were saying in your report.
Yeah, and I think as long as we're stacking up why it's not a precedent.
Yeah, that's, yeah.
That's important,
Yes,
which will be a
for sure.
challenge for Ollie's one.
Yes.
Right.
I do note that the applicant referred to an application which was the same or similar to this one, done in 2003, where it was signed off under
23.
Yeah, sorry, yeah, 2023.
Yeah,
Signed off under delegated authority, it did get a section 100. And that's what she was hanging her hat on.
yeah.
I found that and I did.
Well, when I went back to her though, I said to her that, what did I say? I said something along the lines of, there are some that have been done in that way, but the panel has become increasingly concerned with the number and the effect that might have.
And the simple fact is that,
Now, everything else will be going to panels. That's all I've said.
and a misapprehension of the thing of minor and tender. That's the key thing.
But that was 2 years ago. We've had other stuff that's come in the last.
We've learned since then.
We've learned since then.
And,
Wow.
and I'm happy to own the fact that I probably did give the delegation back. And I was.
But it's the continual
incorrectly.
changes that are
Incorrectly.
coming through that means that we need to kind of manage what's going on in there.
Repeating Queensbury. Huh?
Until such time as the zone changes to enable this activity without a resource consent.
If I've done that incorrectly, then I own that and we're not doing it incorrectly anymore. Right, any other questions of Kirsten? No. Right, on that basis, I can say that the decision of the hearing panel is reserved. The formal decision will be in writing. That period of 15 working days. In the event release the decision is delayed, that can be advised delayed. The hearing is now adjourned. Yeah, Jake? Right, reconvene this meeting of the Central Otago District Council Hearings Panel. We'll go to item number 2516.4, RC 250220. This is the properly convened meeting of the hearing panel called for the purpose of hearing submissions in relation to a resource application land use consent at 3 Loggerhead Lane, Hazelby. I'd ask the Minute Secretary to report on proceedings to date.
Statutory requirements under section 95 of the Resource Management Act have been complied with. Section 42A report prepared by the planning consultant has been circulated to address for service and all submitters. The submissions received have been identified in the.
Thank you. The following procedure will be followed for the hearing. The panel may ask questions. Council's officers or its consultants will direct any questions, points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence. The submitters or their representatives will then be invited to make submissions and present evidence. The section 42A report writer will then be invited to provide a right of reply following a hearing of evidence and submissions. The applicant will then have the right of reply, but shall not be permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask all parties appearing identify themselves. Start with the panel. I'm Neil Gillespie, currently the chair of the panel, and Mrs. Person and Cooney to my left. Karen Lyons is joined by Jesse, looking after the admin support, and we have Anne Rogers, technical advisor for the panel, and the planning consultant, Kirsten Royce. The applicant.
Chairman, good morning, everybody. My name is Jake Woodward, Resource Consents Planner, and with me I have the applicant, Ms. and Johnson.
Ingrid Johnston, yes.
Welcome, thank you. And our submitted.
Carmen Doran.
Right. So it's a bit of a formal process we have to go through. Try and keep it as simple and as complicated as we can. I'll move that the 42A report prepared by the planning consultant be taken as read. Someone like to second that? Again, all in favour?
Aye.
That's carried. Thank you. Right, pass over to you, Jake, on behalf of the applicant. We've got your evidence, and I'll, the drill. Make sure we know what we need to know from it, and we'll follow up with any questions we may have.
Thank you, Mr. Chairman. What I'll do is I'll just print it off the site plan. This is not new. Maybe one for everyone. Thank you. So Ms. Lyons is just handing out the site plan, which was included in the documentation that was submitted. And I think what would be really helpful just for this process, if the panel are able to open up the assessment of effects and turn to page or section 5.1, which is an overview of the proposal. And at the same time, I distributed some photos as part of my evidence. And those photos could be attention.
The 5.1 is the overall scheme in your.
Yeah, yep. So what I'll do.
404 of our. And those photos there.
Correct, yeah, it'll be about 8 or 9 of them. Yeah. So what I intend to do, just for the benefit of the panel, is just do a very brief overview on the nature of this application. And I suppose for simplicity, I'd like to just speak to, there's sort of a number of separate elements, each seeking a retrospective consent. I just want to sort of speak to perhaps the some of the key earlier existing structures that have been on site for some time first, and work my way through that before I get to some of the more contentious issues that I detail in my evidence. So with the plan in front of us, I just want to point out, you can see that there's a number of structures on here clearly identified, including the main ones, the studio, 2 smaller sheds and a cabin. Now, from what I understand is earlier this year in around March, the applicant received a notice to fix letter from the building control team in relation to the cabin that you can see in the northernmost corner. Several days later, the applicant received a planning notice from the monitoring team in relation to that cabin, but also goes as far as identifying the 2 sheds in the main dwelling. And that letter specifically identifies a potential risk or potential infringement to the setback requirements. This is on the basis that council has no records of resource consent attached to this property. And I've subsequently checked and that is something that I agree with. I just want to start with these 2 sheds, and I can confirm, and it was detailed in some aerial photograph, that those sheds were on site before houses were built. And that is shown in figure 4 of my assessment of effects under section 5. One was built circa 2018, 29. So those sheds would have been on site prior to then.
I don't say figure 4.
Figure 4 in the assessment of effects. Yeah, so that'll be under section 5.1.2, the AEE.
Right.
Yes. Nine of the AEE. Yep.
Page 316, I think.
I got it far. I took, sorry.
Everything that I'll speak to will be roughly on sort of 3 or 4 pages.
Sorry. Yeah, my fellow panel members, I went to another agenda item and just happened to coincide with the same numbering.
Yeah.
Probably because the same person did the.
So look, there's 2 sheds there. Now I've made it clear in my application, I don't understand why it were never identified as requiring a resource consent at any given time when the applicant applied for main dwelling or any other subsequent structures. At the time or pre-PC 19, the side yard rule has a number of exemptions. So that rule, which is now superseded, 7.3.6C, side yard requirements, and the exemptions are as follows. Any accessory building can be located in a side yard, so long as there's 3 metres unobstructed access down one side. So the accessory building does not exceed 10 metres. Height of the structure doesn't exceed 2.7 metres, and the written approval from the adjoining neighbours is provided at the time of building consent. Those sheds. I can't find any record for any building consents. I can't find any record for the APA. At the time that those sheds were established, it would have complied with the 3 metres unobstructed access. But for all intents and purposes, I've triggered the current setback rule as it applied today in terms of internal side yards, of which there are no exemptions nowadays. But both myself and Ms. Royce agree that the effects of those 2 sheds, which have been pre-existing for quite some time, are less than minor. They are adjacent to the existing right-of-way. They sit more or less or protrude ever so slightly above the height of an existing opaque fence. And non-habitable structures, as I understand it from the applicant, they are for storage. The only changes that the applicant had done to those sheds was she basically applied a wooden cladding exterior to the existing tin structure. As I mentioned, myself and Ms. Royce are in agreement that the effects on those structures are a non-event. Next structure I want to speak to is in relation to this cabin, which is the main reason why we're here today, or the reason why this has all come about. And as I understand it, the structure was built without a building consent. And the applicant has subsequently gone through the process of applying for a certificate of acceptance. Now, that certificate of acceptance has been issued. As part of that process, the applicant is required to provide a fire retardant on the structure. Although I do believe it's part of the fence. That was provided as part of the certificate of acceptance, and that has subsequently been approved. But in terms of the resource consent side of things, I note that the cabin does not have power does not have any plumbing. And if we scroll down to the images which I've included in figure 2, so you need to go back 2 pages in my assessment of effects, you can see that it's being utilised as a gym, which I understand from the applicant to doing strengthening works and things like that for health and wellbeing reasons. And that structure has been designed to be consistent to the main dwelling, so a log cabin exterior. In terms of effects in relation to the resource consent, so that structure there would reach the internal setback requirements as well. Cabin is not located directly in line with the residential dwelling on adjacent property at number 5 Ogden Lane. As I mentioned, it's not habitable, it just utilises a gym. There's no plumbing or electrical fixture. Height and the placement of the structure is to a large degree screened by the fence, with the exception of the upper portion of the gable. Both myself and Ms. Royce are in agreement that the dominant shading and the potential loss of privacy and overlooking that particular structure will be no more than minor on adjacent properties. I add to that the ground profile, the cabin relative to the neighbouring property is lower. The adjacent property at number 5 Ogden Lane gradually rises to where the dwelling is located. As part of my assessment and as agreed to in the section 43, but of the effects on that structure is no more than that. So that brings me to the main dwelling. And if I could ask the panel to scroll down to section 5.1.3 of the assessment of effects. You have to bear with me as we move through this. So as I understand it, the dwelling obtained a building consent and a number of variations in 2018. And the nature of the inspections and so on have been detailed in the evidence that we have supplied by licensed building practitioner Dodd. But in through my investigations, the residential dwelling was not identified as needing a resource consent of any description. A survey was undertaken, which the outcome of that survey is shown in figure 7, my report, and it details the dwelling as being located 1.73 metres from the internal boundary. The overhangs or the eaves are located 810 mils from the boundary. Near the deck, which is more or less in line with the eaves. The closest that deck gets to the boundary is approximately 670 mils. In trying to determine whether or not there was a non-compliance in order to respond to the council's monitoring requests, I went back and had a look at the underlying building consent. And the site plan detailed the building as shown in figure 6 on that same page as being compliant with the 1.8 metre setback. I think it's important that everyone has an opportunity to look at that figure 6 and you'll see that the building is compliant with the 1.8 metre setback. However, what I think has happened is that that particular image in figure 6, which is the site plan that was submitted as part of the building consent, shows the extent of the foundations, and it did not show the overhangs, which is not an uncommon approach for a lot of architectural drawings. If you scroll down to figure 8, the next page, see that the overhang is a metre wide or a metre deep. So in terms of my investigations, the yard setback requirement as it applied in 2018 is a 1.8 metre setback. But the definition of yards under the district plan, which remains unchanged today, is as follows. Mean the part of a site which is required by this plan to be unoccupied and unobstructed by building from the ground upwards, provided that the eave of any building may project over any minimum yard by not more than 0.6 metres, 25% of the minimum yard, whichever is greater. Just stop there with the definition for the moment. In this case, it's a 1.8 metre setback, so the size of 600 mils, 25% is the minimum yard requirement, whichever is the greater. Well, 25% is around 450 mil. So the reality is in order for that eave to be permitted, it was not to exceed 600 mils. In this case, it's a metre. So from my perspective, in 2018, the resource consent should have been required for the eave. Focusing specifically on the eaves, in terms of effects, both myself and the Section 42A report agree that in terms of dominance, shading, and building bulk, we consider that those are less than minor. And I'd like to turn the panel to the photos, specifically the very first image that were attached to my evidence. Photo number 1. So the photo you should be looking at is taken from standing just to the side of Hogburn Lane, looking back toward the subject site and number 5, Hogburn Lane. What I'm trying to emphasise in this photo is the overhang and the eaves. If that was compliant at 600 mil versus what it is now, it'd be insurmountable, in my opinion, and it isn't. But I consider that the effects of the overhangs are less than minor. It should have required a resource consent, but it didn't. But here we are today, retrospectively seeking to authorise that infringement. Well, I'm going to ask a question before.
Yeah, I think we better if I do. The reading to us before from the application that about prior to plan change 19 about what the yards were, and you said that the definition of yards hasn't changed. Changed.
I don't believe it has. No.
So yeah. I'm not. And then you've said that it's 450 or 600.
Right.
So in this case, the 600 applies.
600 in this case would apply because it's the greater.
So if you go back to your figure 7, the eave to the boundary is 810.
$810 from the boundary, yep. So 1.9. So we've got 1.8 metres with that.
I thought you went on to say therefore it didn't comply, but what you told me, I'm thinking got to be more than 600.
Not more than 600 over. It can't protrude within the setback by more than 600. So the edge of the building is 1.73 from the boundary. And then the eaves are identified as a metre on the building consent. I think where the inconsistency in the numbers come from is that
Oh, so that eve should have only been able to exclude 600, shouldn't have been 1 metre, should have only been able to 600.
it should, the eaves can't be greater than 600.
Yeah, that's right, I got myself confused with the metre and the 600, so.
Oh, okay.
That's right, so that 1 metre that's shown on figure 8, to be compliant, that should have been 600. That's right, yeah, sorry, thank you, I was getting myself confused, but thank you.
Just on that point, however, before I move on to the next issue, is you'll note that the dwelling has been surveyed as 1.73 metres on the boundary, despite the fact that it was shown as compliant on the building control plan. Now, from what I understand, that's just a product of the thickness of the cladding of the building. The building is comprised of quite significant logs. It's a log cabin. And I note in Mr. Dodd's evidence that the inspections were carried out by council, which determined that the siting and the setback were as per the plans. And that would have been done prior to the, I guess, to the cladding being applied. Mr. Dodd's evidence under paragraph 18A, he basically said the very first inspection that was carried out with the siting and the foundations, and that was a path. So it may well be that once the timber logs were applied, cladding resulted in the outcome of a building that's 1.73 metres away. In any event, in terms of effects of that building, I don't think that minor non-compliant for the cladding and the general location are materially different to what one could perceive as a permitted activity. Just to summarise that point before I move on, both the eaves and the dwelling, in my opinion, I don't think in terms of its location, in terms of its positioning, creates any effect more than what one contemplated as a permitted activity. So that leads us to perhaps one of the more contentious issues is that through my investigations, there is a deck landing that runs around the perimeter of the dwelling. And they are showing that particular deck and landing is shown in photos 3.7 of my attachment. And it runs level around the exterior of the dwelling. When I say level, as in floor level. Going back to the definition of yards, goes on to say that an uncovered deck that is less than 1 metre in height may project over any minimum yard. So this particular deck at its highest point is around 1.6 to 1.7 metres in height, and that's shown in photo 5. You can't really see the numbers here, but I'm just taking a photo to say, look, it's more than 1 metre. The ground slowly tapers away or rises as you head towards the rear of the dwelling. And the deck, which follows the eaves of the building, slowly tapers to compliance. So the application was limited notified to number 5 Hogburn Lane on the basis that the effects were at least minor in terms of potential overlooking effects. Having gone through and sit on that deck a couple of times now, and considering the nature of the proposal, actually, I should probably go back a step and just mention that the deck was actually identified as part of the final code of compliance sign-off of the dwelling, and it was photographed through that final inspection. That was in 2023. So much so that the inspection record a requirement for some changes to the railings just to bring it up to compliance, which was done. and it was subsequently signed off. So once again, the deck itself wasn't actually identified as needing a resource consent during those inspections. Although I understand from the applicant that council planners have been to the site on several occasions, but there is no record advising the need for a resource consent at all. The first time that the applicant has been advised that she needs a resource consent for a breach to setbacks is as per this application.
Before we go on, can I just clarify something? The site plan that you've given us a copy of.
Yeah.
The main dwelling outline there is what?
That's the eaves.
Concrete slab, the eaves, the deck.
At the exterior, the roof, yeah.
And from taking your photograph 3, the boundary, the eave, I think you said pretty much lines up with the
Bang on with this 1.8,
with the eve.
based on that plan provided by the architect.
Because on in your application at figure 7, it showed the building deck just slightly wider than the eve. I'm reading the red line.
Oh, the deck is a little bit beyond the eaves anyway, like when you stand on the deck and you look up.
Yeah.
It's got quite a wide island, I would call it if you look at photo 3, you can see the top of the railing. It's a wide balustrade.
Yeah.
But you can see in that photo 3, it sits just outside of the eaves.
Yeah, cool. Which has been reinforced by what's shown on that photo, figure 7 in the application. Yeah, cool, thank you. Yep.
So now, I'd like to just direct the panel to my evidence. You can follow along on paragraph 22. Page 8. In terms of the deck, Mr. Royce's recommendation at this time is for the deck to be removed due to potential effects associated with loss of privacy, spaciousness around the buildings, dominance. I hold a different opinion to Mr. Royce for the following reasons. So as per Mr. Dodd's evidence, the deck has been constructed to provide accessibility around the perimeter of the dwelling, whereby the dwelling itself sits elevated above the ground level. The width of less than 1 metre, about 700 to 800 mils wide. The deck effectively functioned as a circulation walkway rather than an outdoor living area. As such, it is not an area that would typically be used for extended periods of occupation, and its primary function remains as circulation for residents around the dwelling. While some degree of overlooking towards number 5 Hogburn Lane may occur when the deck is in use, the extent of those effects, in my opinion, are comparable to, if not less than, the level of mutual visibility that already exists between number 5 and 7 Hogburn Lane. Now, I illustrate this figure on the following page. Get to in a moment. Illustrate the living area of number 5 Hogburn Lane benefiting from open and views into the adjoining property at number 7 Hogburn Lane. This type of intervisibility is common and anticipated within a residential environment, and the district plan permits outdoor living area to be established immediately adjacent to property boundaries, and in the absence of a 1.8 metre opaque fence or any sort of boundary screening, it is entirely lawful for residents to see into a neighbouring property. To sort of emphasise the point, if you had 2 properties side by side that are level in terms of topography, and there just happens to be a standard post and wire fence or a low height coloured steel fence of some description, the effects of somebody around their dwelling in that 1.8 metre setback and looking over into the neighbour's yard is permitted by the district plan. In this context, the overlooking associated with the subject deck, in my view, consistent with the existing character of the area, does not give rise to effects that are appreciably different from those already experienced from other neighbouring. Again, given its narrow width, functional purpose of the walkway, it does not facilitate prolonged occupation. Accordingly, any effects are considered to be no more than minor. The photo that I referred to is on the next page. And I ended up under figure 1. Paragraph 22D. In addition, the outdoor space most affected by any potential overlooking from a deck appeared to function primarily as a parking area. Didn't make it clear in my evidence, but if I direct the panel back to my photos.
Sorry, I was confused by that, but you said it was a parking area.
Yeah, sorry,
The deck is over.
Yeah, you.
Sorry.
Yeah.
Sorry, I'm new to this, but
That's
I
right,
was
yeah.
confused by that, but
Hopefully pick that up.
Yeah. I just want to direct the panel to photo 2. I'm just conscious that you haven't got a copy of this in front of you, so.
sorry, I looked at it on my phone. I'm looking over your shoulder.
So that's a photo from the corner of the deck where it can note in breach. Overlooking the outdoor area. Now, I just note that this photo was taken separately from the ones I took 2 weeks ago. Although unformed, back to my evidence, although unformed, the applicant has observed that vehicles are typically parked directly beneath the deck during the intermittent period when 5 Hogben Lane is occupied. The established primary outdoor living areas, at least from my observation, clearly identified on the opposite side of the dwelling, as shown in my figure 1, my evidence. Accordingly, the area subject to potential visibility is not one that currently is used for regular outdoor living or prolonged occupation. A review of the property file for number 5 Hogben Lane, so I've ordered the building consent documentation for that site, confirms that the internal space layout, and this is in figure 2 of my evidence, that is most exposed to potential overlook appears to be the kitchen. All bedrooms within that dwelling are located at the opposite end of the dwelling, where the boundary setbacks are compliant. In my opinion, kitchens are not typically regarded as sensitive in terms of privacy, nor are they spaces where occupants spend an extended period of time compared to, say, a living room or a bedroom. Appreciate that some people enjoy cooking. The internal layout of a dwelling therefore further mitigates potential privacy effects from the deck. When I take all of this into account, I also undertook an assessment of the level of overlooking that is actually achievable from the portions of the deck and the walkway and even sections within the actual property itself, and what that looks like on the neighbouring property. And I've just included a quick photo under figure 3 of my evidence. It shows a significant degree of visibility into 5 Hogben Lane is already possible from these omitted areas. So the extent of overlooking from the compliant section is again comparable to, and in practical terms, no less than what is occurring from the non-compliant sections of the deck. This demonstrates that the setback infringement does not materially increase the overall level of intervisibility between the 2 properties. Along that whole stretch of landing by the deck, there is an element of overlooking. Start off as permitted and progressively become non-compliant as you make your way to the northern. Paragraph 23, in assessing the relevant matters of discretion relating to privacy and outlook, considers that the deck walkway will not generate overlooking effects beyond those reasonably anticipated as a permitted activity between properties without a 1.8 metre fence. And also note that within the medium density zone, appreciate this is not the medium density zone, but decks may be constructed as close as 1 metre as of right, resulting in a comparable level of intervisibility between properties. So the degree of overlooking associated with the deck is within a range that is contemplated in a residential context, depends on the zoning, obviously. The potential effects are further mitigated by the deck prime function. Within providing for extended, prolonged. Paragraph 26, for these reasons, I consider that the retention of the deck, an element that provides essential accessibility and forms an integral component to the dwelling design, is considered appropriate. And its removal is not warranted. Just reminding myself here under paragraph 27 that we've also got a non-compliant for parking. So be addressed now before we perhaps go back to the deck. But, I've identified a breach to the parking requirements, and I think that's just evolved over time. Every residential property in a low density zone is required to provide one on-site parking space. Over time, the applicant has domesticated the, I guess you would call it the entrance or the front yard of that property. So much so that you couldn't feasibly park the car in there without pulling the fence down and moving all of the pot plants and so on and so forth. The applicant herself doesn't drive, nor does she own a vehicle, hence her reason for domesticating the front yard. But I agree with Ms. Royce that effects of the lack of parking in an area where all surrounding residents are sporadically vacant and where substantial parking is afforded in the vicinity. I consider those effects are less than minor, and I agree with Mr. Royce that any disputes as it relates to the right of way can be dealt with through other mechanisms afforded under the property law. I note that when I visited the site, I was spoiled for choice in terms of parking. I ended up parking down the road and going for a walk. Suppose at this point, if the panel had any specific questions on that, the last part of my address is just in relation to the submission. So we've received a submission here from the neighbouring property number 5, who's with us today. And so that submission addresses a couple of key things: fire risk, unsightly, breach of rules, privacy, and blocked parking. On paragraph 29, it's not entirely clear which of the above matters relate to which specific element of the resource consent, noting that there's a number of respective elements here. Sure, we can seek clarification today, but notwithstanding, my response is as follows. So the fire risk can only relate to 2 buildings, the dwelling itself and the cabin. All other structures are either or on other boundary than not pre-existing. So I consider they're not relevant to the submission. But I consider that the fire risk issue is resolved because the dwelling and the deck have a current code of compliance from council. I don't think any further consideration of fire risk is necessary. And regarding the cabin, that had recently obtained a certificate of acceptance, which a fireproof wall is required. Fire risk for those 2 elements, I think for all intents and purposes, are either certified or have been given a certificate to become certified. Whether the structures are unsightly or not is subjective. Structures, in my view, have been built with a high degree of coherence in terms of design and visual aesthetics. So much so that the structures together are relatively sympathetic. Visually, I consider the structures in combination and not inappropriate. The issue around parking, we've discussed that already. But I'm unable to verify or see any evidence of parking obstruction, and I just want to note for the record that I sent a request to the council asking for any complaints in relation to the subject site, and I have not received a single response. I haven't gone as far as doing on Lagoima. In any case, based on my site visit, look, there's substantial room for parking. The applicant itself doesn't sign it. The applicant sell their property and move on, and somebody else who has a vehicle decides to purchase the property, there are opportunities for them to park in the vicinity, which in my opinion, would materially undermine residential amenities. And the final point there, I won't touch on the objectives and policy, but just in terms of the draft conditions that have been recommended, recommendation, should the panel accept assessment in relation to the retention of the deck, is that condition 2, which requires the deck to be removed, deleted, should consent be approved. I appreciate there's sort of a number of moving parts here, so I'm happy to just respond to any questions.
Thanks, Jake. Very helpful. So I'll turn to the sheds. Just to confirm. I'd need to go.
Is that answer?
Yeah, they are not contemplated being taken away, are they?
No.
So easy to be asking, is it going into parking? Is that, so that with the sheds in place, the only parking ability is, and you talked about the investigated area, which is the gap between the shed and the cab.
Yeah.
That would be
As you walk in the gate, you've got the cabin on your right, you've got the sheds on the left, bunch of stairways,
Yep.
a whole bunch of pot plants and gardens and things like that.
there's opportunity for parking in that. I haven't been, I didn't take the trip out to have a look.
You get an opportunity, have a look, it's very tight.
Yeah.
Could be an opportunity there.
And the sheds, are they movable in terms of, are they on piles, concrete slab?
They are tin shed, but I will double check with the applicant. The two shed next to the right of way,
Yeah,
how are they fixed to the ground?
on concrete, Gus Clark told me,
Gus Clark
Yeah.
told you?
Gus Clark at this time told me I should actually put the shade on concrete pads and put stormwater pipes. So all the stormwater that comes from the studio down.
Yeah.
Is all concreted underneath and is fixed. So I did under the advice of Gus, what he told me. So it's all clean
Yeah.
and tidy, and you can see the stormwater is going actually underneath out.
No, that's fine. So concrete pad, but are they, and can you recall how are they bolted to the concrete?
Oh, yes, yes, yes. Gus,
So that,
Gus was
that's
very
fine,
much
yeah.
onto it.
I'm
Oh,
just
yes.
conscious of time.
yeah.
Gus and Murray McCutcheon, the both told me, and they came twice a week actually.
Yeah. Okay.
No, cool, thank you, that's right, just, so future owners, where I was casting my mind to, is that could be an opportunity as well, but the sheds have to shift and concrete to come up, all those sort of things, so that's right, no.
I can say between, so there is a 3 meter gap from the cabin to the first shade, because there is a large tree there, a big tree and garden. So if that is removed, car parking is possible. I'll just leave it at the moment. I don't need it.
No, thank you. That's my only question. I think, Jake, you did a good job of taking us through the issues and clearly I think given the submitted shortly, there may be some that pick up out of that I'll raise later on if I need to, but otherwise thank you for taking them through. I understand what the applicant's case is. Ian?
If it's a deck, not a deck. Just, can you tease out this walkway? Explain that, how that is different. It makes it a walkway, not a deck. But I think in one of those photographs, I do see chairs sitting there and is it a couch which has got something covering over to keep it waterproof at present, or,
use it as storage.
You're using the storage at the moment.
Yes,
Yeah.
all this part is used in storage.
Or underneath, yeah, so when I was there's a whole bunch of bits and pieces under the deck, and so all of the plastic wrapping is for.
Yeah, but I'm talking actually on the deck there. One of
On the
those
deck,
images. Did I see some chairs which are lying down and it looks like?
Oh,
Just a bench, it's just a bench with 2 chairs,
Yeah.
Jack and Jill, I call it. And I have nowhere to do it, and I don't use it, I'm just one person. It's not for sitting there, it's just stored there. You still.
So the purpose of this deck is so you can get around the house.
you can squeeze past. I mean, the deck goes right, it goes right around the house. Goes right around the house. But there's lots of bits and pieces lying on the deck.
Can I please say something what Gus has informed me? At this time, Gus has suggested, because it's a serious wind sounding 1.110 or whatever, Oliver McCutcheon and Oliver and Gus told me for security and safety, because it's above 1.50 meters, to make it clear, because there's a window coming out, the children can't fall down if any one of my grandchildren come. So I should actually have a connection, but as narrow as possible because of the boundary alignment. So they arranged it, Oliver and McIntosh and Gus Clark with the building manager, Peter Pavel, they arranged it with him to do all of that. I have been actually only the person to pay. I did not know anything. I didn't understand anything. It's security and safety because of the high wind zone and the heights of the ground, the most ground.
So essentially, the term deck is pretty loose. It's more of a walkway around the exterior of the building, at the level of the building.
To make it secure and safe, yes.
Accessibility.
Thank you. You happy with that? Right. It's rocky going. Oh,
Yes.
you mind if I call you that?
Sorry,
You mind if I call you that?
very well.
Call you Carmen.
Right, yeah,
Yeah.
sorry.
Right, so now we're in the stage where, as the submitter, you have a chance to state your case. So it's not an opportunity of an examination of each other. You may well in your submission to us pose some questions that you might find that we'll then ask to find out. That's the process. So yeah, you get an opportunity now to expand on your submission and the concerns that you have.
Yeah, where do you want to start? There's quite a few things.
Start wherever you want to go, and we'll sit there and listen, and we'll go from there.
So on the deck piece, probably start there. It actually overlooks our living area, not our kitchen. So you can see, I think it's photo 3 you were talking about. What are we talking about? Photo
2. The evidence.
Photo 3, you can see the deck goes all the way along with the chairs. And then you can see photo 4, so that blue curtain, that's actually our living area. So when we read that it's only the kitchen that it overlooks, that's not correct. And absolutely, when we are sitting in there and people are on the deck, or Ingrid is on the deck, it feels very, very close. So that one, the privacy side of things is relevant. I don't have evidence. I don't have, a picture of someone sitting on the deck or anything like that to share, but just wanted to correct that is overlooking our living area.
I'm just going to ask this, and you may not know the answer, but it's a question that, so Jake will pick it up when he replies. But I suspect that the response could be something along the lines of, at that point, that deck is within the area. I think that's what part of the evidence that I heard was about. So I'm not saying you might be 100% correct, but I think what Jake was trying to tell us was that partway along it becomes, if you like, permitted.
If you look on this map, we're halfway along on there is what looks into our living room.
Yep.
So that bit's that's too close to the boundary already, I think. But anyhow, Jake can confirm.
Yeah.
So from a privacy perspective, that's one part. From a fire perspective, so in Naseby, fire risk is a massive thing every year. We hear from the fire brigade, we hear from Naseby Vision, we have information shared about not stacking firewood close to your house or to your fence. We have a lot of information shared about fire risk. So having significant wooden buildings there and saying it's not a fire risk to me feels in conflict to the information that we have had shared locally. And then on the parking, so it actually impacts down the neighbour down the end more. Number one, Hogburn Lane, because it blocks their parking there. It is quite often that there are vehicles parked outside. You can even see it in the last photo, the aerial shot. And the evidence that's supplied that there was a vehicle parked there, that vehicle, that white ute with 2 roof boxes has been parked there a lot. And while there all the time, it is for us and for everyone else, and the access risk when there are buildings out there. So our neighbour at the neighbour to number 3. So at number 1, they've shared some photos that have been submitted as evidence, and then I shared some additional photos just from when I was there recently a couple of weeks ago. So it shows that it's not an isolated incident, the parking point. And I think that the idea that if someone was to take over the property in the future, that they would take out a tree and take out sheds and put their own parking in, that seems a bit of a stretch as well. But I guess the key for us is that deck and overlooking to the property.
And what you were saying is, in particular with the deck, is that looking at that site plan, it shows the extent of the eave, which is not as much as the deck starts from further back, contrary to what Jake had said earlier. So I'll make that observation for him to pick up in the reply, because I think he knows what I'm getting at. Just an observation about the fire risk. At the end of the day, you're allowed to build houses of wood. And so a lot of the stuff that,
But not on the boundary,
well,
like the cabin being on the boundary, and the fact that those are not habitable, those cabins and sheds were there first, were being habited in the early days. So that also, for me, feels like a stretch to say that it couldn't be habited again in future.
could be, but we'll need a consent to be paying for that. So, and I'm sure a lot of things that probably did happen in days gone by when no one did know there was issues going on. So, and I mean, clearly here that there's an underlying issue about what building consent, how it got to that. And
Yeah.
unfortunately, it's not. Well, fortunately, it's not that common. It does happen, and generally because left and right hand aren't connected, I'd like to think that we're in a better place for that these days.
It just feels like there's so many things that you don't follow the rules, then what are the rules there for?
Yep. Yeah. Okay. Anything else you'd like to add? Other questions? Any
I've got
questions?
one.
Yes.
Did you read that? Thank you.
My husband got sick of
Yes. Yes. Thank you. So now we go over to our section 42A report writer to any response to the evidence that's been produced and any changes in the recommendations that they've made.
It is, unfortunate that we find ourselves in this position, and some of the checks and balances which perhaps should have taken place didn't. I'd just like to note that I picked up on Jake's point about the shed being permitted, providing there were a number of criteria met. And one of those was that there was a 3.3 metre wide yard on the other boundary. And so again, at the time that the house was built, that 3 metre yard would not have been maintained. However, we're now assessing it under Plan Change 19, which provides for the 1.8 metre setback. So again, that's another matter where the siding of the house probably should have taken that into consideration. I'm not convinced with the use of or the obvious evidence with chairs on the deck and that sort of thing. I'm not convinced that it's only used as a walkway. And that there is the potential for that to be, and regardless of whether it is or not at this time, there is the potential for it to be used as a deck. And I do think that there is some privacy issues on number 5 Holborn Lane. I stand by my recommendation. In terms of the car parking, I have put an advice note strongly encouraging that car parking be provided and note that should the panel be of a mind, they could require that to be a condition. The difficulty that I had in assessing the effects is that there is already legislation that governs rights of way under the Land Transfer Act or the Property Law Act. One of those, I mentioned it in my report. Anyway, which prevents people impeding the use of a right of way through parking on it or other means. And so in that regard, there is another remedy. And we need to be careful in the RMA that we don't duplicate function. And so therefore there is another legislation which governs the control of rights of way. We could take any questions.
Thanks, Kirsten. So I'll start with that. But that doesn't, other legislation in relation to the right of way doesn't prevent this council from requiring a parking area to be provided and maintained.
Absolutely not. And in fact, the plan does direct that a car park be provided. Correct.
And then just in relation to the sheds in particular,
Yes.
can you just confirm from a strict planning side of things about let's them stay where they are?
What let's them stay. So I have just looked at the effects of those. They are in breach of the 1.8 metre. So the right of way is not a front yard, it is a side yard. And so therefore they are in breach of the 1.8 metre setback. However, I've looked at the effects of those and determined that in terms of what my discretion is restricted to, which is privacy dominant shading and those aren't going to affect the right of way in that respect.
Thank you. That clarifies for me. And given what has been said from Jake and from the submitter, that you paying your condition too.
Yes.
Thank you. Right, no other questions from the panel. So the applicant for right of reply, do you want to quickly confer with your client, or do you ready to wing it? I mean, to do it. Sorry.
Mr. Chairman, I think if we adjourn for 5 minutes.
Yep.
And just one other thing too, has there been some photos that's been distributed by a neighbour that we haven't been?
Yeah, I'm so sorry, Jake. This morning there was 2 additional photos that I've just been partway through there that I can give you. If you want I have copies of them, or I can email them to you.
Look, if
They were just
I can have a,
not evidence, tabled. So tabled as part of the submission.
I think if I can just have a glance over them.
Oh, potentially they are.
We'll just adjourn while come back when you redo it.
Yeah.
Yep. Rightio. We'll reconvene this meeting and we'll now pass back to the applicant for the right of reply. Jake,
Thank you, Mr. Chairman. Mr. Chairman, I think probably just have to reserve our response and provide that in writing.
Yep.
I had a conversation with the applicant and a neighbour outside, but I think the situation is a bit pressured that I'm just not convinced that the acceptance that she's giving me is, I don't know if I want to offer that out right now. So if I can have an opportunity to just provide a right of reply,
Yep.
and we'll deal with everything else
Timeframe?
within the next couple of days before the end of the year.
Before
I think
Christmas, it needs to be
I
done
think
before
realistically,
Christmas.
if we can, just by the 19th of this
Okay,
month.
yeah, I'm happy with that. Yeah, yeah.
Yeah. I think ultimately the applicant needs to have a think about some potential solutions overnight.
Yes.
And then we will provide a response to that. I don't really have much to say about these photos. I mean, aside from the fact that it clearly shows the parking area that we assumed was being used at number 5 Hogburn Lane, in fact, being utilised as a car parking space. But a car that's parking there to pick up a neighbour, I'll pick up the applicant.
My driver picks me up because I'm nearly blind.
Yeah, so we'll just have to try and see what sort of response we can provide to that. But yeah, we can have until the 19th.
Right, on that basis, I can say, reserve their right of reply in writing by the 19th of December. Thank you very much. And otherwise, this hearing is adjourned. Righto, let's reconvene this meeting of the Central Otago District Council Hearings Panel. We'll move on now to agenda item number 25.16.5. See 250257. This is the properly convened meeting of the hearings panel called for the purpose of hearing submissions in relation to the resource consent application for the subdivision and land use consent at 78 Pearson Road, Cromwell. That's the Minute Secretary report on proceedings today.
Statutory requirements under section 95 of the Resource Management Act have been complied with. The section 42A report prepared by the planning consultant has been circulated for address for service, and all submitters. The submissions received have been identified in the report.
Thank you. The following procedure will be followed for the hearing. The panel may ask questions. Council officer or consultants shall make any questions or points of clarification through the chair. The chair shall be the person asking the question. Applicant and applicant representative will be invited to make submissions and present evidence. The submitters and their representatives will then be invited to make submissions and present evidence. Section 42A report writer will then provide to reply. Right of reply following the hearing of evidence and submissions, and the applicant then has the right of reply, but shall not be permitted to go into reverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask that all parties appear to identify themselves. So the panel, Neil Gillespie on the chair. We're commissioners today, actually, not councillors. And fellow commissioners, Martin Person and Ian Cooney. And we've got Taryn and Jesse making sure we get the admin side of things worked out. Planning consultant Kirsten there, and to your right, Ian Rogers, technical advisor to the panel. Move that the section. Oh, sorry, I should ask. I had all planned. The applicant would like to introduce themselves. That'd be a good idea.
Thank you, Mr. Chairman. My name is Jake Woodward, Resource Consent Planner. With me today, I've got Simon Backstone and his son Lyndon Backstone, the applicant, and then at the back here we've got Sam and.
Well, can they come and sit up the front?
Well, they can do. That's right.
Are they trying to hide in the back or something here?
I only mentioned 2 names.
Let's making sure these two behave themselves.
Yeah.
Okay. Thank Chris. Last person.
Yes.
All same last name.
You're more than welcome to join us at the front if you want to. I'd just ignore them. Rightio. Welcome everybody. I'll move that the report of the planning consultant be taken as read.
Second.
All in favour?
Aye.
It's carried. Thank you. And I'll hand over to the applicant to present their submission.
Mr. Chairman, I understand the evidence has been distributed and read as well. You don't want me to read the evidence verbatim?
Not unless you think it's entirely important. Mr. Coforth, no.
Yeah.
Don't tell me the important stuff you want me to know as you normally would do, Jack. You should know by now.
Sure, no worries. So we have an application here for 78 Pearson Road, Cromwell. The site's located in the rural residential notation under the Central Otago District Plan. The site at 1.91 hectares, contains an existing residential dwelling and approximately 1.2 to 1.3 hectares of areas. Site also holds a resource consent for travellers accommodation for 2 detached separate structures. That consent hasn't been given effect to just yet. This proposal seeks to subdivide around the existing dwelling, circa 4,000 square metres, with the balance lot of 1.5 hectares. And it will contain the existing shares. The building platform, despite the fact that the site's located in a rural residential zone, is promoted in the southeastern corner of the property. The application is supported by a landscape assessment by Mr. Moore. We recommend the number of landscape mitigation along the southern boundary adjacent to the Kawerau River. And Mr. Moore's landscape assessment considers that the area with heritage and recreational values contains minimal indigenous vegetation and is characterised by the orchards and modest built form in the vicinity. Mr. Moore's assessment concludes that the addition of one dwelling will have low adverse effects or less than minor physical effects due to the site's low sensitivity to change, minimal earthwork and the proposed mitigation motive, as well as the fact that we are proposing to relinquish the travellers accommodation consent. We've also included a report from Mr. Ray McLeod, a productive land economist, and he has assessed the application in terms of the existing cherry orchard, in terms of commercial viability. The parts of his assessment is twofold. First is that fundamentally the returns that one would see from a 1.2 hectare cherry operation is not something that you would give up your day job for. Notwithstanding, Mr. McLeod's assessment goes as far as determining that any clearance required in order to accommodate the proposed residential activity and access and the servicing can be offset by additional planting elsewhere, recognising that the current planting framework is conventional, but future planting in the form of more efficient, higher quality varieties will help offset any loss. But ultimately, from a resource management perspective, we're basically taking the position that the no net loss outcome in terms of productive capacity, and through that process, the residential dwelling can be accommodated within that existing environment. All standard residential servicing matters proposed, including on-site wastewater disposal, firefighting tank for firefighting, obviously, and water supply, which will be provided through via an on-site existing bore shared with the subject site and the neighbours. Overall, my assessment is in agreement with that provided by Mr. Royce, and that consider that the landscaping, productive capacity, servicing, access requirements are all no more than minor, and that's reflected by the fact that the application was volunteered on a volunteered notification, of which, with the exception of one submission in opposition from Runaka in relation to wastewater and landscaping matters, the response and the feedback has been positive, and that is further supported by the adjacent neighbours providing their affected party approval. Myself and Mr. Royce are in agreement that the proposal is broadly consistent with the objectives and policy framework for the rural resource area as it relates to the residential notation, as well as consistent with the regional policy study. Ms. Royce and I have covered off precedent, and we consider that each application needs to be considered on its own merits, and that the decision to grant this consent not apply that similar applications elsewhere in the zone would necessarily be appropriate. We agree that the same conclusion that despite the non-compliance with the averaging criteria, the proposal has been determined to generate no more than minor landscape servicing amenity productivity effects. No persons are determined to be adversely affected. And this in turn confirms that the proposal meets the gateway test under section 104D for non-compliant activity. In terms of the proposed conditions, we're largely in agreement with the conditions that have been promoted, or just a few minor points. But just a couple of key points that I wanted to add on. The section 42A recommends the provision of a consent notice for reverse sensitivity. However, unless I've overlooked it, I didn't necessarily see a specific condition worded as such. I recommend the inclusion of a condition to be registered on the title, detailed in paragraph 28 of my evidence. In addition to that, the section 42A recommends the provision of a condition 5B, which requires any trees that are being removed from the proposed building platform to be replaced elsewhere on the site, and evidence to be provided to council. While the applicant does not oppose the inclusion of this condition, I have taken the view that its imposition is not considered necessary. The purpose of the productive capacity assessment that we provided was to demonstrate that the extent proposed building platform, proposed lot 2, would not result in a net loss of productive capacity when compared with the existing environment. And his evaluation just simply confirmed that there are opportunities to establish newer, more efficient fruit varieties, indicating that the subdivision will not compromise productive capacity. So in reality, a landowner may remove those crops. Blackstones could remove the crops today and revert the land to pasture, should that be something they decide to do. But our application details that productive capacity can be maintained if a landowner chooses to pursue option going forward. Other than that, Mr. Chairman, that's the extent of my evidence. It's relatively to the point, and for the most part in agreement, the recommendation put forward by Mr. Royce. So happy to respond to questions accordingly.
Thanks, Jake. The issue of the size of the allotments in the area, average 2, which means you can go as small as you like, as long as you've got a subdivision where you start with more than sort of 4 and a bit, you can, well, I think it's keep on going. Does it seem that all the other assessments, landscape and all the other things line up, that rule becomes a bit of a nonsense? Which of what this application portrays is the allotment size of less than 2 don't matter because all the other objectives and policies and things can be met. Trying to get a feel for saying, well, that seems to be an odds to an average of 2. What that otherwise means is those that have got enough land holdings to subdivide down, because I guess if you start with the right number, the calculation, but if you start with the right number, you get lots of small blocks to get through a consent process that would enable it. How do you think that conflict of the rule about the minimum allotment size then trades off back to the objectives and policies?
Yeah, Mr. Commissioner, I don't think the rule is a nonsense by any means. Obviously, this idea of allowing for some degree of residential to co-locate with productive capacity and appropriate. Obviously, some of the key objectives and policies talks about maintenance of open space and character and amenity and whatever landscape values are present at the time, the extent to which they are maintained. So I think, recognising that the rule framework provides us with the opportunity to consider those effects and what it looks like on the environment. And so the applicant has gone through that process in terms of considering the specifics of each of those elements that may be compromised, going against the averaging criteria. So certainly it is a difficult, it is a difficult measure in terms of averaging, which the council have, through their district plan review process, have recognised has some shortcoming. And ultimately, it's the opportunity of a non-compliant process to demonstrate, well, if the effects are no more than minor, and you can demonstrate the elements of maintenance of your open space, the maintenance of rural amenity value, then that's the assessment that is reached. So for those reasons, you have to remember that someone driving down Pearson Road isn't going to be materially compromised or subject to a degree of effects when seeing a residential dwelling, because that is the inherent character which Mr. Moore has defined as well. The ability to be able to absorb residential activity is part and parcel of the assessment process which is presented to the panel today.
Be fair to say that you're starting with a blank sheet of paper, you might make the assessments a bit different to give some substance to a minimum allotment.
Potentially, that's sort of the approach that we've taken with PC 19, isn't it? And also, I understand council has been working with the avenues, including academic with Otago University, just to understand what is the most appropriate mechanism for managing land use. And certainly the consensus through a lot of that research is averaging probably might not necessarily tick the box. And we do see in other districts, the averaging criteria is being removed in favour of a minimum.
Supposed to average. It's about, I'll talk to myself.
You, I think in your application provided figure 2 in the planners report, showed lot sizes below around 1 hectare back on the 16th of December. If I was to 2022, if I was to look at that and using that same logic, then you could double or triple the number of sections that are 1 hectare in size using the same logic that's got these. That aside, how many of those do you know were actually done as a result of a subdivision or hangovers, dare I say, from Vincent County?
I think the majority of them were done through the through that averaging criteria. So looking at that figure 2, in that particular in the section 42A report, particularly those properties at 132, 134 and 146 Pearson Road, so that's to the south toward the Bannockburn Bridge. That was actually done through 3 separate resource consent applications, and
the average was met.
The average was met. And it was basically it was an exploitation of the averaging criteria.
That's a good term for it.
Yep. But what it's created along that road frontage, relatively intense residential development. There's obviously a number of more recent applications that have occurred by way of whether it's a boundary adjustment. There's multiple units up at number 498, so 49A and B, Pearson Road. So there's, yeah, certainly for the most part, a lot of those were done through that controlled activity process. But you can see what level of fragmentation has resulted. And at the end of the day, it'll probably be a question of cumulative effects. At what point the landscape architect turn around and say we can't absorb anymore? What point will the productive capacity be determined as no longer appropriate? I think in the applicant's case with 1.2 hectares planted, be demonstrated is not economically viable at this point in time, albeit could be offset anyway through improved practices. The site's already somewhat compromised compared to the larger blocks.
And speaking of product, in relation to the report from the cloud, there's absolutely no doubt that cherries there in their current form, nothing at all, never will be just how to get a small fortune because you started with a large one. Simple terms.
Yep.
But that doesn't mean to say that there's not other productive uses, and like you yourself said, chop the cherries down, put it back to pasture, and can make it into productive use.
Yeah, I mean, it's not really a question around productive capacity. I mean, the land is productive so long as it's got water and everything. It's that return, the economic return, any number that will actually be promoted. That's something that someone decides to pursue.
Cherry sort of things, I might say things that I'm not supposed to say.
So, you wouldn't be wrong. Nice day, that's the main thing.
Any questions?
No.
Ian? Right, nothing else. There's no submitters to speak to their submissions. We're aware that commissions were in favour, with the exception of the Runaka, who have said no, but if you do, then add a vegetation and 50 metres away for wastewater discharge septic tank. So that's the extent of what we've got from that. So I hand over to Kirsten from the planning consultant chair to speak to her report and any changes she might want to make if she's been persuaded by Jake to make any changes.
Thank you. So I think one of the key things that sets us at, I know Jake and I have both discussed precedent, but I think something that we both are aware of is that there is the surrender of the travellers' accommodation, which is located in a similar location as what the proposed building platform is going to be. And so therefore, when you're looking at domestication, you know, there is a bit of an offset there in terms of, you know, a single residential dwelling compared to two travellers' cabins. And so those would be removed, there'd no longer be consent for those, and then instead there would be a residential dwelling put on. In terms of the consent notice regarding adverse sensitivity, I agree, I did miss that off, so thank you for picking that up, Jake.
That's why you left it off, wasn't it?
All right. And then in terms of the typo in 6G, I agree with that. In terms of the productivity, it is rural residential, so that condition 5B. It is rural residential, so there's no not like there's an obligation to under the NPS HPL, for example, to maintain productivity quite the same way. And Jake is correct that there's no restriction on removing those cherry trees and converting it to pasture or lavender or any other number of small lifestyle block kind of use. The reason I promoted that condition was because of the recommendations or the assessment in the productivity report. But I do understand that potentially it is a significant cost to the applicant that may not be imposed on other land users in that area. Thanks. I'm happy to take any questions.
Thank you. And appreciate, clarify the question I was going to have about replacement trees. That came from. Mr. McLeod was here. I would like to throw in some curly questions.
Yeah, I do apologise for not necessarily bringing them up.
Mr. Weaver been here, we can ask him some questions too.
Right, Channel, any questions, for Kirsten?
Subdivision last time.
Um. Yeah, no questions, thank you. Jake, what a reply.
Item of five, that's us.
You're done. Thank you.
It's easy.
On that basis, the decision of the hearings panel is reserved. The full decision will be in writing, will be available within 15 statutory period of 15 working days. In the event the release of the decision is delayed, the applicant will advise of the delay. Thank you, everybody.
Thank you, Mr. Chairman. Thank you, panel.
Okay, we'll reconvene this meeting of the Central Otago District Council Hearings Panel. Move to agenda item 2516.6, resource consent 250289. This is the properly convened meeting of the Hearings Panel to hearing a resource application for land use consent at 4 Highlands Avenue, Cromwell. Minutes here to report on proceedings today.
Statutory requirements under section 95 of the Resource Management Act have been complied with. The section 42A report prepared by the planning consultant has been circulated to a brief for service.
Thank you. Following procedure will be followed for the hearing. The panel may ask questions. Council's officers or its consultants will direct any questions, points of clarification through the chair. The chair shall be deemed to be the person asking the question. The applicant or the applicant's representative will be involved to make submissions and present evidence. The section 42A report is online. Behind you, but she's behind me, isn't she? Yeah.
Hi.
Will be invited to provide a right of reply following the hearing of evidence and submissions. The applicant has been enough the right of reply. It's not permitted to again traverse the evidence nor raise new evidence. Before proceeding with the hearing, I'd ask that all parties appearing identify themselves, not for your benefit, because you already met us today, but for our 42A who is online. Neil Gillespie, currently the chair of the panel today. Martin McPherson and Cooney join me. Taryn to my right, looking after admin with Jesse, who's just walking into the room, and Anne Rogers is our technical advisor to the panel. And online is the section 42A report, Kim Banks. Welcome, Kim.
Thank you. Good afternoon.
And Zoe, I'll hand over to you to introduce yourself and go from there.
Good afternoon. I'm Zoe McCormack. I'm a the applicant.
I'll cap Joe and welcome. I'll just move that the section 42A report be taken as read. Second. In favour?
Aye.
Carry. Thank you. Right, and your capable hands. Yes. Do you have a summary or anything or something?
Yes, the same as earlier.
Same as earlier.
You don't want another copy of it?
I don't think we need to kill a tree, do we?
Yep, I agree.
Yes.
Thank you.
For the purpose of this and probably for the benefit of the 42A report writer, probably worth going through that.
I'll read through it. Yep. So my name is Zoe McCormack. I'm a planner with 10 years experience locally in planner based Landpro. While I did not write the application, I support its contents and take responsibility for the application here. I visited the site, not prepared any additional evidence, and provide a summary below the key points when we're in agreement with section 42A officers report. We agree that the consenting background description is accurate. Agree with the amended consent notice conditions as presented in the section 42A report. That the description of the activity is accurate, and that the maximum site coverage is 88%. The landscape is 3.78% proposed. The design complies with all other design requirements of the consent notice 1245.331.5. We agree with the effects assessment and Noting that the built form integrates well with the existing context. The additional building coverage is supportive of the underlying purpose of the site for vehicle parking and associated activities. Sun landscaping softens the scale of the built form and that overall green space provided for by reserve opposite the site. That the architectural design of the building mitigates effects of breaching the site coverage and landscaping. The design is consistent with others in the same subdivision. Wider public are not affected because the effects are internalised into a private gated subdivision. Design is consistent with the developer's intended outcomes for the Highlands Innovation Technology Park. The increased site coverage will not adversely affect stormwater. The new planning context of the Highlands Innovation Technology Park means that considerable weight can be placed on a written approval from the Design Review Board, as they maintain the architectural integrity, character and amenity of the estate. We agree with the note that the 42A officer raised that the note of Valentine Barker, the original consent notice was established in 2013, which was prior to the Valentine Barker decision. While there's been no rezoning of land, the park itself is more urban than rural, meaning that the existing environment has changed since the consent notice was originally developed. And we agree with the conclusion that the effects of the proposed variations are less than minor and that not allowing the consent notice variation may obstruct the purpose and principles of the Act. To answer any questions you have.
Thank you. I'd like to get an understanding as to the applicant's perspective as to why they couldn't have the development with meeting those 75%, 15%. What's the overriding, I suppose, desire or logic to depart from that? Own understood it to be limits to what's proposed. And that's not. I'm not saying anyway it's wrong. Just trying to get a feel for the why.
I might start by answering the question then. And your experience of the site there. So we've discussed that the design, not every lot or lot owner in Highlands has applied for variations to their consent notices. But that doesn't mean that they have worked within the rules in other ways where they might have provided greater landscaping, but for instance, along the side of a building that isn't then visible. So the site coverage is meeting the 75%, but it's not creating a greater visual impact by, like offsetting that. So it's not that it goes from side to side, it's that the dwelling itself, the construction itself will be smaller, might be narrower, so that it fits within that consent notice, but it doesn't still then have the same landscaping aspect. Well, there's 15% available for that, but it doesn't have the same visual impact. The underlying reason for that part of the Highlands is that it is for the sole purpose of vehicles and maintenance with residential ancillary. With the nature of Highlands, the high investment and enjoyment of motor vehicles is that they are preferable to be inside. And by having a larger footprint, you've got more spaces for more cars to be shown and to be housed inside rather than on the outside. So it provides for greater enjoyment of the underlying use of the site.
I think with the design of that particular building, where it's positioned on the corner, one of the conversations that we had mainly was getting a car, being able to put a car straight in there. So sort of race cars that are going there, they've got no turning circle. So to actually come in off that corner, you can't turn a race car at 90 degrees. So that's why there's a turntable in there to go in, turn around, come out the other way, which gives the flow of access on the access and entry. And then we're going back to the landscaping, because as you go around Highlands that you visited, you'll see like a lot of the landscaping you see looks elaborate, but a lot of it's on actually Highlands land. So even though we've shown what's going on with what landscaping we're putting in, it's all goes in conjunction with having landscaping in front of that property when it's done. with Highland itself. So it's not, I'd say, just concrete on the outside, there'll be landscaping incorporated in that. Going with the Highlands. Couldn't physically get the car to turn in, and then obviously you can't put the camber on the road. It won't go straight in off. Well,
I should have thought of that.
yeah, it's been a common thing on quite a lot of because the camber's quite, when the road's narrow, the camber's obviously quite steep off.
Just trying, I'm sure somewhere amongst the stuff there was a plan that showed the site plan of the building on the site. Anybody know where that is? Because I'm going to probably finding it. Yeah, maybe.
That one there.
I'll look at the good old fashioned site plan that shows the building shape.
The appendix to the 42A report has the plans that were to be recommended to be approved, which has the site plan on it.
Thank you.
Of the building.
I don't,
You just mentioned it.
I might have been just imagining it. I'm just trying to get a feel for,
No site plan in the appendix, Mr. Chair.
no,
No, there's,
Is this a plan here? It says like.
yeah, just trying, but that shows the ground floor slab,
Show the
doesn't
boundaries.
show the boundaries. Just trying to get a feel for what's down the sides and across the back. Well, I think it's not very much. So I was looking, I was looking,
On the boundary, it's like you're showing 5 mil off the boundaries from the side and the rear. So everything, because there's no access to the rear of the
right, so that's, sorry, the percentage of the site coverage at, would it end up to be 83 or something, is it?
The 88.
Yeah. And the only, so the, take the, what's it called? Site plan. Yeah, that is the site, the square rectangle is the site. And then the stuff that's not covered is the grey shaded area, and some of that will be landscape. Right. You had seen something that told me that's what it looked like. Right. So effectively, apart from a little bit of the front is 100% site coverage.
Yeah.
In simple terms, without, you know, without.
Yeah, with developing, so properties on that road, so street, drive, whatever, that particular property has no benefit from having anything at the rear because it's backing onto the track at Highlands.
Yeah.
So the idea is to bring and working alongside with Highlands, it's making sure the visual of their buildings flowing on down there is essential for them. So.
Thank you. That's clarified. Was in my head that was about what the case was, and I want to make sure that I was right. But now I can see on that plan that it is actually, yeah. Right. I don't have any other questions, Martin. Ian? Right. Thank you. What could be asked them previously? Probably got an idea of the answers. Is I'll get that straightforward, but it's clear what the applicant's proposing. Now hand over to Kim, the section 42A report writer, to come and present your report, make any comments, observations, any changes you might want to make to what you recommended. And if we have any questions for you.
Thank you. My report is as written and taken as read, and I agree with the summary that's been provided by Ms. McCormack. I don't have any recommended changes following that, but yeah, essentially my assessment is that the effects of the proposal are less than minor. The location is a bespoke sort of development zone framework, and the consent notice provides those guidelines within which buildings should be designed. The increased site coverage is aligned with the intended activities that are enabled by the previous land use consents for that zone, and it supports the vehicle related activities as the applicants have outlined, that the increased site coverage is preferable to enable that access and manoeuvring within the building. So yeah, my assessment is the effects are internalised, less than minor. There are no adverse effects on persons, and I've given some consideration to the case law around consent notices and the circumstances in which it is appropriate or not, may not be, to amend those. And in this instance, and as has been outlined in the application, in looking back at the consent history, it is sort of apparent that the consent notice was volunteered, and although it formed part of the decision and the assessment of effects, it was a mechanism to provide some design control within the development and manage the internal amenity of that development. And in looking at that context, I think in this case, given that it's appropriate to consider a variation to those conditions, and in this case, that variation, in my opinion, will have less than minor effects, and so I have recommended that it be granted and the consent notice condition varied accordingly.
Thank you. So from the point of view of precedent, and just looking at the subdivision layout, if we look at numbers 8 and number 6 and number 2 and number 5, Highlands Way, those owners all applied for the same sort of thing. Would your view likely remain the same?
I'm not fully across the details of all the previous applications, but I don't think there's been a large number to breach the site coverage. But I think in terms of precedent, it is a relevant consideration as to with each sequential application that might come along, how that's going to affect the entire internal amenity of the development. So yeah, I think I can't comment for previous cases, but in this case, I've obviously taken consideration to what the receiving environment is at the moment with this development added to that, and then future applications would need to consider that, any possible broader effects.
It'd be fair to say that for future applications, it would be of something similar to this one in the adjoining sections. It'd be pretty hard to say no once this one's been said yes to. That'd be a reasonable observation. If the same building, the identical building was built next door, because the sections are same size, it's quite likely that the assessment will be the same. Do you think? I can't hold you to it. I'm just trying to get a feel for saying, the precedent issue becomes an issue, and it may not be something that people in there are concerned about. In fact, they might want to have it, but then it does start to make a mockery of the whole consent notice side of things.
Yes, well, the consent notice, looking back at the previous decisions, wasn't the landscape considerations were more around the landscape effects of the development externally, and there was a landscape assessment done in the original development, whereas the consent notice conditions have arisen through being volunteered by the applicant as a way of creating a good quality urban environment internally and ensuring a high standard of development. In terms of future applications, they need to be assessed on their merits. In this case, the design of the building, the internal layout and what's proposed, and the high design quality, which is being supported by the Design Review Board, goes to mitigating the effects of that increased site coverage and reduced landscaping. So those same matters would be relevant to future applications. And it doesn't necessarily mean that they'll achieve the same outcome. It depends what the particular development proposed is at that time.
Because we have the legacy of this being in a rural resource area for a start, so it's miles away from being anything near to what should be what you normally expect. in, a whole lot of buildings like this, but the whole issue about the rural zoning side of things is well and truly gone and hardly relevant going forward, do you think?
Yeah, well, the development's been enabled by the previous resource consents in terms of the land use that's permitted. So the zoning to some extent has less of relevance. It's an assessment based on what the previous decision and consents allow for.
Thank you. None. Ian? Technical questions? No. Thank you. Back to the
Thank you.
applicant for a right of reply. Anything you want to add that you tell me last time? You can tell me again if you like.
Only one, I guess, one other clarification to make is that what Kev's spoken to me about today is that even if a landowner abides by all of the consent notices, if they submit their design to the Highlands Design Review Board, they still might decline the design or the look of the building. So it's not to say that by granting a consent for a consent notice then enables that type of development to occur in Highlands, because they have a requirement for how they like things to look there.
Guess what to me is that I get the role of the design review board, makes perfect sense. It is going to control the quality in line with the thinking of those that are on that board as each application comes in, that we change over time, perhaps, whatever. There's no doubt about what they're trying to do. What I find there's the conflict between that and a consent notice that was quite clear that the applicant put in place the first time. Maybe the message should have been, you should have got this fixed some time ago and done something about the whole zoning of the whole damn place and made it a bit tidier. Then I wouldn't have to grapple, the panel wouldn't have to grapple with sort of saying, well, you proposed it and now you're saying we don't agree with it anymore. It's kind of, I think, a bit frustrating. It's what gives the RMA a bad name?
Yeah, and there are cases where you would take a resource consent application process to enable a subdivision. You would do it as a plan change.
Yeah.
And so there are those options available to applicants.
I think from my experience, the grey areas is like is to achieve the landscaping. And some of the people have bought the building, say 150 mil off the rear boundary and counted that strip as the landscaping. It really goes against what Highlands were trying to achieve because it's the visual impact of what they're doing. And then so the neighbouring properties, when then the next review board goes, as the development goes on, they see how it fits within Park's growing development. And that's where the approval comes from for the design. Like on previous ones where we've made sure it fits in and doesn't put a tilt panel in front of somebody's window, or it's just trying to make it all, that criteria also contradicts itself, like you've pointed out, you know? Yeah.
Anyway, that's not for us to fix them.
Yeah.
No other questions? If you took my bit of paper away, I'll do it off the top of my head.
She did.
That's all.
Oh, yeah.
No, I'm not going to do it.
You sure?
The decision that this hearing is, the decision of the hearing panel is reserved. Will be available statutory period 15 working days, and should that need to be extended, the applicant will be advised. The hearing is now adjourned.